There are 3 questions a police officer in Canada will ask you in almost the same order every single time, and every one of them sounds like small talk. Do you know why I stopped you? Where are you coming from tonight? You do not mind if I have a quick look, do you? Friendly, conversational, the sort of thing you would answer without thinking because someone in a uniform asked you in a pleasant voice and you have nothing to hide. And each one of those 3 is doing a completely different job in law. Not one of them is something you are required to answer. And the most dangerous thing about all 3 is exactly how pleasant they are. I am going to take them apart one at a time. What each one is actually for. What Canadian law genuinely requires of you. And the one answer that handles all 3 without making you sound like a difficult person or getting you into any more trouble than you are already in. My name is James Hale. I am a criminal defense lawyer, and I have spent over a decade in police stations and courtrooms in Canada. This is general information about Canadian law. It is not legal advice, and I am not your lawyer. If something has already happened to you, contact a lawyer today, not this week. Before I take a single question apart, let me give you the half of the picture that is against you. Because if I only gave you the good half, you would be no safer at all. Under the provincial highway traffic legislation in every province in Canada, a driver of a motor vehicle on a public highway is required to stop their vehicle when signaled or requested to do so by a police officer in uniform. In Ontario, that obligation sits in Section 216 of the Highway Traffic Act. In British Columbia, it sits in Section 83 of the Motor Vehicle Act. The equivalent provision exists in every province. You stop. That obligation is not a request. Failing to stop is a criminal offense under Section 249.1 of the Criminal Code of Canada and carries serious consequences. So stopping is not where you have any choice. And once you are stopped, provincial highway traffic legislation in every province requires a driver to produce their license, insurance, and vehicle permit on demand by a police officer. In Ontario, Sections 7 and 33 of the Highway Traffic Act. The equivalent provisions exist across the country. You produce those documents, you do it immediately, you do it without argument, and you give your name and address if asked. Because failing to identify yourself as a driver is a provincial offense in most jurisdictions. So you stop, you produce the documents, you give your name. That is the complete list of what Canadian law genuinely requires of a driver at a roadside stop. And now look very carefully at what is not on that list. Because everything the 3 questions are asking for, every single word of it, sits entirely outside the obligations I just described. Here is how decent people lose this, and it is not stupidity or carelessness. They answer because silence in front of a police officer feels like an accusation of themselves. Saying nothing feels like guilt. So they fill the space, they explain, they chat, they make the situation comfortable, because that is what reasonable people do when someone is standing at their window at night and asking them things. And every word of that explanation is information the officer did not have when he walked up to the car. He did not have to work for a single sentence of it. You handed it over freely because you were trying to be helpful. Your good manners are the mechanism. That is not cynicism about policing. It is simply what the technique is designed to produce, and it is why the questions are worded the way they are. Question 1, do you know why I stopped you? It sounds like the start of a friendly exchange. It is actually one of the oldest admission gathering techniques in investigative interviewing. It is doing one job only. It is fishing for a confession before the officer has told you anything at all. He may have stopped you for a brake light. He may have stopped you for a minor traffic matter. But if you answer honestly, you will tell him something he did not know. Maybe I was going a bit fast back there. Was it the way I changed lanes? I think one of my taillights might be out. Every one of those answers is a voluntary admission from someone who is trying to be cooperative, now sitting in the officer's notebook in your own words. Notice what he has not done. He has not told you why he stopped you. He has asked you to guess, and your guess is now his evidence before he has established anything against you. There is no provision in the criminal code, no provision in any provincial highway traffic act, and no provision in the charter that requires you to speculate about your own conduct. The duty is to stop, produce documents, and identify yourself as the driver. There is no duty to explain what you think you did wrong. And watch what happens to your answer. Whatever it is, if you guess correctly, he has your admission. If you guess incorrectly, he now knows there was a second thing you were worried about. And if you say you have no idea, he tells you anyway because he has to. He is required by Section 10A of the Charter to inform every detained person promptly of the reasons for the detention. The reason was always going to reach you. It was just a question of whether your guess got there first. There is no version of question 1 that you come out of ahead by answering it. That is what makes it such a consistently effective opening. Question 2, where are you coming from tonight? Or the same question in the other direction. Where are you headed? This one is not after a confession. It is building something different entirely. And to understand why it matters, you need to understand the legal architecture around searches in Canada. Section 8 of the Canadian Charter of Rights and Freedoms protects everyone from unreasonable search and seizure. A warrantless search is presumptively unreasonable under R.V. Collins, 1987, and the burden of establishing reasonableness rests on the Crown. Under Section 9 of the Charter, you have the right not to be arbitrarily detained. The Supreme Court of Canada confirmed in R.V. Mann 2004 that an investigative detention, meaning a detention for investigation purposes beyond the original traffic stop, requires reasonable grounds to detain. The court in Mann was specific about what those grounds require. They must be based on objectively discernible facts, not a mere hunch or a generalized suspicion. And any search accompanying that detention requires reasonable grounds to search, with the scope of the search limited to what is reasonably necessary to address the specific safety concern or investigative purpose that justified it. The Supreme Court went further in R.V. Clayton 2007, addressing the use of roadblocks and systemic stops, and confirmed that the threshold for individual investigative detentions remains grounded in specific, articulable facts about the particular person being detained, not simply about the class of people who might be in a given area. R.V. Le 2019, which addressed police entry into a private space, reaffirmed that the totality of the interaction must be assessed to determine whether a detention occurred and whether it was arbitrary. Reasonable grounds is built from pieces, a place, a time, something that does not align with something else. The hesitation before you answered, the answer that changed slightly, none of those things is evidence of wrongdoing on its own, but grounds are cumulative and an officer is entitled to build them from what you volunteer. The Supreme Court addressed this in R.V. Grant 2009, confirming that the totality of the circumstances is assessed in determining whether reasonable grounds existed. Every piece of information you provide about your evening, your route, your activities, your companions, potentially goes into that totality. Your travel plans are not on the list of things you are required to provide. Where you have been tonight is not in any Provincial Highway Traffic Act. Where you are going is not in the criminal code. It is information the officer wants. It is not information the law requires you to give. Every word of it is voluntary. Question 3, and this is the one that actually costs people their case permanently. You do not mind if I have a quick look, do you? Listen carefully to the structure of that sentence. It is not, may I search your vehicle? It is a negative framing with the agreement already embedded in it, delivered casually, often while the officer's gaze has already moved past your window and toward the back seat. And it is not a power, it is a request. And that distinction tells you something enormous. Under Section 8 of the Charter, a search requires lawful authority. Without a warrant, a search requires a recognized exception to the warrant requirement. The recognized exceptions include searches incident to arrest, searches based on exigent circumstances, searches conducted under specific statutory powers, and consent searches. If the officer is asking for your permission, one of two things is true. Either he has independent grounds and does not need your consent at all, or he does not have them and your consent is the only legal route he has to conduct the search. Consent is not a formality that precedes a lawful search. It is in many cases the thing that makes the search lawful in the first place. The Supreme Court of Canada addressed consent and the waiver of charter rights in our verse. Wills, 1992. A valid consent to search must be informed and voluntary, but the consequence of giving it is complete. Once you have consented, the question of whether the officer had independent grounds to search ceases to be relevant. The consent is the authority, and everything found in the search is admissible as the product of a lawful consensual search. And I want to stay on question 3 longer. Because of the 3 questions, this is the only one that cannot be repaired afterward. If an officer searches your vehicle on the basis of independently established grounds, those grounds exist somewhere. They are in his notes, they are on the body camera, they are in the record of the search the officer is required to provide, and every one of those can be examined by a lawyer whose job is to look at exactly that. The question of whether the grounds were sufficient is a question a court can answer. If those grounds are found inadequate, evidence discovered in the search may be excluded under Section 242 of the Charter, which gives the court discretion to exclude evidence obtained through a charter violation where admitting it would bring the administration of justice into disrepute. If the officer searches your vehicle because you said yes, there is nothing to examine, no grounds were needed, so none were recorded. The question of whether the officer was entitled to open your trunk is not weakened. It is gone. It was never available to be asked. A search on grounds leaves a record that can be challenged. A search on consent leaves only your agreement, and no one has ever successfully challenged their own agreement, which is exactly why the question is delivered in the friendliest voice of the entire encounter. Now put all 3 questions side by side, because the sequence is not accidental. Question 1 tries to get you to admit something before the officer has established anything. Question 2 gathers the factual material that reasonable grounds for a detention or search can be built from. Question 3 asks you to hand over the search in case questions 1 and 2 did not produce enough. 3 questions, 3 completely different legal doors into the same situation. And if you are a polite person, having what feels like a reasonable conversation, you will walk him through all 3 without registering any of them as anything other than small talk. That is the design. The friendliness is not incidental. It is the most effective interviewing technique available, and it works precisely because you are a decent person. Before I give you the answer, 1 minute of straight talk that matters more than anything else in this video. If you are ever arrested in Canada, ask for a lawyer immediately. Section 10B of the Charter gives you the right, upon arrest or detention, to retain and instruct counsel without delay and to be informed of that right. It costs you nothing to invoke it, and it matters more than any script. Ask for the duty counsel. It is available at no cost through legal aid in every province, and it is available 24 hours a day. Almost nobody invokes it as quickly as they should. That right exists precisely for the moment we are talking about. Now the answer, one answer. It handles all 3 questions. It covers all 3 legal doors. And it does not require you to be rude, hostile, or difficult. I would prefer not to answer any questions. Here are my documents. And no, I do not consent to any search. 3 clauses, 1 for each of the 3 doors. Let me take it apart, because every piece is doing specific work. I would prefer not to answer any questions. Notice, it is not I refuse, and it is not you cannot ask me that. It is a stated preference delivered calmly. Under Canadian law, you have the right to remain silent. Section 7 of the Charter protects the right to silence as a principle of fundamental justice, confirmed by the Supreme Court in R.V. Hebert, 1990. The common law right to silence applies to any person detained by the state. You are not required to answer police questions. You are not required to explain your evening. You are not required to speculate about your own conduct. This one clause covers questions 1 and 2 simultaneously without requiring you to identify which category each question belongs to. Here are my documents. This is the clause that keeps you out of trouble, and it is the one people leave out. You are doing the thing provincial highway traffic law actually requires, immediately and without argument. You are not being obstructive. You are not refusing a lawful obligation. You are being precise about which part is compulsory and complying with it completely. This clause is what makes the whole answer work. Without it, declining to answer questions could be framed as uncooperative. With it, you are demonstrating clearly that you know the difference between what the law requires and what it does not. And no, I do not consent to any search. That closes the 3rd door. If the officer has independent, reasonable grounds, he will search anyway, and that search is lawful, and you must not physically interfere. But he will now have to have those grounds, and he will have to be able to articulate them. And that articulation lives somewhere that can be examined afterward. If he searches without consent and without grounds, Section 242 of the Charter is available to challenge the admissibility of anything found. If the officer searches without consent and without independent grounds, Section 242 of the Charter gives the court discretion to exclude anything found. The grant framework requires the court to weigh the seriousness of the Charter infringing conduct, the impact of the Charter breach on the charter-protected interests of the person and society's interest in adjudication on the merits. Where the breach is serious and the impact on the individual's reasonable expectation of privacy is significant, exclusion is often the result. That argument is available when grounds were absent. It is never available when consent was given, because the consent is the lawful authority for the search. The analysis stops there. Then you stop. You do not explain the answer. You do not apologize for it. You do not fill the silence that follows, because the silence that follows is itself a technique. It is designed to produce discomfort that resolves in more words from you. Sit with it. Now the line you absolutely do not cross. This is where someone who has watched a video like this one and feels newly confident about their rights can make a much worse mistake than answering the 3 questions. Declining to answer questions is lawful. Refusing consent to search is lawful. Physically obstructing an officer who is exercising a lawful power is a criminal offense under Section 129 of the Criminal Code, and it is a separate problem from whatever the original stop was about. The moment the officer names a specific legal power, the moment he says he has reasonable grounds and is conducting a search under Section 11 of the Controlled Drugs and Substances Act, or under a specific provision of the Criminal Code, or under a valid warrant, your role changes completely. You step back. You do not block anything. You do not put a hand near anyone. You give your documents. You decline questions calmly. You decline consent once clearly, and then you do not interfere with a power that has been named, because you do not win this at the window of your car. Nobody ever has. You win it afterward in a courtroom when a lawyer examines whether the grounds that were stated actually existed. And that is a completely different fight, one that is actually winnable. The questions I get most often about this: will staying quiet make me look guilty at the roadside? No. And there is a specific reason grounded in Canadian law. Section 7 of the Charter and the common law right to silence confirmed in R.B. Hebert mean that you are not required to assist in your own prosecution. The right to remain silent is a fundamental legal right in Canada. It is not an admission of guilt. It is an exercise of a right that exists because the legal system is accusatorial, meaning the state must prove its case against you, not the other way around. At a roadside, before you are under caution and before a formal investigation has been declared, your silence is not an exhibit. It is your right. However, and this matters, the moment the officer formally cautions you, the position changes. A caution is the Canadian equivalent of a warning that what you say may be used as evidence. The moment you hear those words, the situation has escalated. And the single most important thing to say is that you want to speak to a lawyer before you say anything else. Then you mean it. What if I am a passenger rather than the driver? The obligations in provincial highway traffic legislation to produce documents and identify yourself apply to the driver of the vehicle. A passenger is in a significantly different position. The duty to identify yourself as a passenger is not the same across all provinces and all circumstances, and you should know your specific provincial rules. But the Charter applies to passengers as well as drivers, and a passenger who is part of a stop is detained within the meaning of Section 9 inches the same way the driver is. The Supreme Court confirmed in R.V. Grant that the detention analysis applies to anyone whose liberty has been restrained by a state action. So a passenger who has been told to stay in the vehicle while the driver is questioned is detained, the charter is engaged, and the right to silence and the right to counsel under Section 10B apply. If the answer to who else is in the car comes out of your mouth automatically without you thinking about what you are saying, that is worth knowing before it happens. Can the officer search anyway after I decline consent? Yes. If the officer has independent, reasonable grounds, he can search without your consent, and that search is lawful. What you have changed is that he now has to have those grounds and has to be able to state what they were. And that record, his articulation of the grounds, lives somewhere that can be examined. The argument about whether those grounds were sufficient is an argument a court can have. The argument about whether a consensual search should have happened is one the court cannot have because the consent resolves it. What if this happens at my front door rather than in a vehicle? The three questions barely change in phrasing. Is everything all right in there tonight? Who else is home? Would you mind if I just stepped in for a moment? But something important changes in your favor. None of the provincial highway traffic obligations apply at your own door. There is no legal requirement at your home to produce any document, identify yourself in the way a driver must, or explain your evening. And the threshold for police to enter a private dwelling without consent is considerably higher. Section 8 of the Charter applies with particular force to a private home, and the Supreme Court confirmed in R.V. Feeney 1997 that police generally require a warrant to enter a private residence to make an arrest, subject to narrow exceptions for hot pursuit and exigent circumstances. The safe approach at your own door is the same as at the car window. Answer nothing. Ask what specific power is being exercised and require it to be named before you do anything further. And the question I hear most, I already answered all three. It happened 2 weeks ago. What now? Write down every word of it you can still remember tonight before it fades further. Memories of specific conversations fade faster than people expect, and the detail that seems obvious now may not be available to you in a month. Your contemporaneous record matters. Ask for the body camera footage of your own encounter. Under the Privacy Act and access to information legislation in Canada, you have rights to access records about yourself held by federal government bodies, including the RCMP. For provincial police services, access requests go through the relevant provincial freedom of information legislation. The process is not instant, but the footage of your own stop is your information and you can ask for it. Ask what grounds were recorded for any search that was conducted. If the answer is that the search was conducted on the basis of your consent, that tells you exactly what happened. You cannot unsay what you said, but you can find out precisely what was done with it, and that is often the most important piece of information available to you. Let me play the whole encounter through once so you have heard it before you ever have to use it. Officer, good evening. Do you know why I stopped you? You, no. Here are my license, registration, and insurance. Officer, where were you coming from tonight? You, I would prefer not to answer any questions. Officer, why not? Is there something you are not telling me? You, no, I just prefer not to answer any questions. Officer, you do not mind if I just take a quick look in the back, do you? You, I do not consent to any search. And now one of two things happens, and both of them are better for you than the conversation you were about to have. Either the officer names a specific power and conducts a search anyway, in which case he had grounds all along, and you stand back and write down every word of what he says the moment he is gone.